In this video, I'll explain why using AI to hire, fire, or manage employees in Florida could already be putting your business at serious legal risk. By the end of this video, you'll learn exactly which laws apply to your AI tools right now, what Florida's new AI Bill of Rights means for your employees, and the 3 steps you need to take today before your next hire goes through the algorithm. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. And I can tell you from working with business owners every single week, most of them have no idea that their AI software just became their biggest liability. Here's what I mean. Right now, thousands of Florida businesses are using artificial intelligence to screen job applicants. They're using it to monitor employee performance, and they're using it to decide who gets promoted and who gets let go. And the reason this is so dangerous is that the law does not care whether a human made the decision or a machine did. The liability lands on you either way. But here's the thing most people get wrong about this topic. Most business owners think AI hiring tools are neutral. They assume that the software is objective. This is the first and most expensive mistake you can make, and I call it the automation alibi. This belief that because a computer made the decision, the company is somehow protected from discrimination claims. The opposite is true. Federal anti-discrimination laws like Title VII of the Civil Rights Act, the Americans and Disabilities Act, and the Age Discrimination in Employment Act all apply to employment decisions, every single one of them. And when those decisions are made by an algorithm, the employer is still the one who faces the lawsuit. Now you're probably thinking, but I did not program the software. I bought it from a vendor. That does not matter, not even a little. The EEOC has made this clear over and over again. Employers remain fully liable under Title VII when their AI tools produce a disparate impact on protected groups. It does not matter that you purchased the tool from a third party. You deployed it, you relied on it, and you are responsible for the outcomes. And actually, the court just confirmed this in a case that every Florida employer needs to know about. It's called Mobley versus Workday. Let me break down why this case changes everything. Derek Mobley is an African-American man over the age of 40 who applied to more than 100 jobs through Workday's hiring platform. He was rejected every single time, not by a human, by an algorithm. He filed a lawsuit alleging that Workday's AI screening tools discriminated against applicants based on race, age, and disability status. And here's where it gets critical. Workday tried to get the case thrown out. They argued that they were not the employer. They were just the software provider. The court disagreed. A federal judge ruled that Workday could be held liable as an agent of the employers who used its systems. The court said that delegating hiring decisions to an automated agent is no different from delegating them to a human being. Nothing in federal anti-discrimination law draws a line between the two. Then, in May of 2025, the court took an even bigger step. It certified a nationwide collective action. That means potentially millions of applicants over age 40 who were rejected through Workday's platform can now join this lawsuit. The judge was direct about it. Widespread discrimination is not a reason to deny notice to a class. Now stop and think about what this means for your business. When you use an AI hiring tool, you are not outsourcing your legal risk. You're multiplying it. And the vendor you bought the software from is not going to be the one writing the settlement check. You are. But wait, it gets worse for Florida employers specifically. And this is the part nobody is talking about. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Florida's legislature is moving fast on AI regulation. Senate Bill 482, known as the Artificial Intelligence Bill of Rights, passed the Florida Senate and it's working its way through the legislature. Governor DeSantis has made this a priority. The proposed effective date is July of this year. And this is not some abstract policy idea. The bill creates specific rights of Florida residents when it comes to artificial intelligence. Now, here's what matters for employers. The bill establishes the right for individuals to know whether they are communicating with a human being or an AI system. It addresses the collection of personal information and biometric data by AI technology companies, and it prohibits Florida government agencies from contracting with AI firms connected to foreign countries of concern like China or Russia. Now, you might be thinking this bill is mostly about chatbots and minors. And on the surface, that's true. But here's what I call the regulatory ripple effect. When a state passes an AI Bill of Rights, it creates a legal framework. That framework establishes definitions. Those definitions get applied to future legislation, and the next round of bills will target employment decisions directly. We are already seeing this pattern play out in other states. Colorado just passed a landmark AI law requiring bias audits for AI used in employment decisions. And California's Civil Rights Council finalized regulations that extend anti-discrimination laws to automated decision systems that are already in effect. And Illinois requires employers to provide notice when AI is used in employment context. New York City already requires bias audits for automated employment decision tools. Florida's not behind. Florida is loading the chamber, and the employers who wait until the law takes effect to start preparing are the ones who will get caught. And here's the part that surprises most of my clients. You do not need a new AI-specific law to face liability for using AI in your workplace. The laws that already exist cover this. I call this the silent enforcers, 3 legal frameworks that are already being used against employers who rely on AI tools. The first is Title VII of the Civil Rights Act. This law prohibits employment discrimination based on race, color, religion, sex, and national origin. When your AI screening tool rejects a disproportionate number of applicants from a protected group, that is a disproportionate impact claim. You do not need to prove intent. The statistical outcome alone can trigger liability, and it does not matter that your AI vendor told you the tool was unbiased. The burden of proof falls on you to demonstrate that the practice is job-related and consistent without business necessity. Now, the second one is the Americans with Disabilities Act. When an AI system screens out applicants based on factors that correlate with disability, gaps in employment history, certain speech patterns in video interviews, typing speed on assessments, that is a potential ADA violation. The employer has a legal obligation to provide reasonable accommodations. An algorithm does not know how to do that. Now, the third is the Florida Civil Rights Act. This is the one most employers forget about entirely. The FCRA prohibits discrimination based on race, color, religion, sex, pregnancy, national origin, age, handicap, and marital status. It applies to employers with 15 or more employees, and it works alongside federal law to give Florida employees additional avenues for filing complaints through the Florida Commission on Human Relations. So when someone tells you there is no AI employment law in Florida, that is wrong. There are at least 3 that apply right now, today, without any new legislation. Instead of hoping your AI tools are compliant, here is exactly what you need to do. I tell every client the same thing. Before you use an AI tool in an employment decision, you need to follow what I call the human override protocol. 3 steps, do them in order, and do them now. Step 1 is the AI audit. Take an inventory of every single tool in your business that touches an employment decision. That includes your applicant tracking system. That includes your resume screening software. That includes your performance monitoring tools, your scheduling algorithms, and your employee ranking systems. Most business owners are shocked when they realize how many AI-driven decisions are happening without any human review. You cannot manage risk you have not identified. Now, step 2 is the bias test. Once you have your inventory, you need to conduct an adverse impact analysis on each tool. This means reviewing the outcomes of your AI systems to determine whether they are disproportionately affecting any protected group. Are more applicants over 40 getting rejected? Are applicants with disabilities being screened out at higher rates? Are certain racial or ethnic groups being filtered at the resume stage? You need the data, and you need to document it. The employers who survive regulatory scrutiny are the ones who can show they tested for bias and took corrective action. Step 3 is a human-in-the-loop requirement. No AI tools should ever make a final employment decision without meaningful human oversight. Not a rubber stamp, not a quick glance at the recommendation, a real substantive review by a qualified human being who has the authority and the information to override the algorithm. The courts are looking at whether employers are exercising genuine oversight. A check-the-box approach will not protect you. Now, here's the most important part of all of this. The employers who take action now are the ones who will be protected later. The ones who wait are the ones who end up as the case studies. The regulatory landscape around AI and employment is tightening faster than most people realize. Florida is moving, the federal courts are moving, and the lawsuits are already here. Do not let an algorithm make decisions that put your entire business at risk. Get your AI systems audited, test for bias, put a human in the loop, and talk to an attorney who understands how these laws apply to your specific situation. Now, if this video helped you understand something you did not know before, hit that like button and subscribe to my channel. Share this with another business owner who needs to hear it. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.